I rise to speak on the Confiscation Amendment Unexplained Wealth Bill 2024. The bill is a culmination of extensive work to deliver on the government commitment in the Community Safety Statement 2018-2019 to review Victoria's asset confiscation and unexplained wealth laws. Although our existing confiscation scheme is relatively robust, there are gaps in the scheme that sophisticated senior organised crime members have continued to take advantage of, to the detriment of Victorians, particularly those organised crime group members who distance themselves from direct offending but continue to play a pivotal role in the movement of funds, property and favours in criminal organisations. As a result, the new unexplained wealth pathway broadens the existing pathways in two substantive ways. The bill amends the Confiscation Act 1997 to strengthen and improve Victoria's existing unexplained wealth laws by introducing a new unexplained wealth order that better targets unlawfully acquired wealth. The Confiscation Amendment Unexplained Wealth Bill 2024 is designed to disrupt the financial backbone of organised crime groups. Money, often the primary incentive for engaging in serious criminal conduct, sustains and motivates these nefarious activities. By severing the flow of unlawfully acquired wealth, we can significantly undermine the infrastructure of organised crime, rendering it less effective and more susceptible to legal intervention. One of the core objectives of this bill is to ensure the economic allure of crime is substantially diminished. By confiscating unlawful obtained wealth, we send a clear and unequivocal message to those engaged in or contemplating serious criminal activities. Victoria will not be a safe haven for ill-gotten gains. It is not merely a matter of stripping away assets. It is about stripping away the power and influence that such wealth confers upon these entities. Moreover, the bill aims to protect our community by preventing these funds from being reinvested into further illegal activities. This initiative shows our commitment to justice and equity. By targeting unexplained wealth, we uphold the principle that no one should unjustly enrich themselves at the expense of society. It reinforces the belief that the rule of law applies equally to all, regardless of one's position or one's resources. The community must see that crime does not pay and that the fruits of illegal activities will be reclaimed and redirected for the public good, contributing to a safer and more just Victoria. The bill introduces several critical amendments to the Confiscation Act 1997 aimed at closing loopholes and enhancing the effectiveness of our asset confiscation regime. Number one, the introduction of a new unexplained wealth order. One of the most significant reforms in this bill is that introduction of the new unexplained wealth order. This provision allows the Director of Public Prosecutions to apply to the court for an unexplained wealth order if there are reasonable grounds to suspect that a person's wealth exceeds their lawfully acquired wealth by at least $200,000. Crucially, this new order does not require a direct connection to criminal activity. This simplifies the legal process and broadens the scope of the law, making it easier to target individuals who have accumulated wealth through illegal means but have insulated themselves from direct criminal activities. Under the current framework, unexplained wealth orders require a connection to criminal activity. This often allows high-level criminals to evade justice by distancing themselves from that direct involvement in criminal acts. The new order will close this gap, enabling law enforcement to hold these individuals accountable based on their unexplained wealth alone. The bill also broadens the definition of wealth to include not only property, but any service, advantage or benefit provided to a person. This comprehensive definition ensures that all forms of unlawfully acquired wealth, including those spent on lavish lifestyles or hidden through complex financial schemes, are captured. This broader definition is essential for targeting sophisticated criminal enterprises that use various means to obscure their ill-gotten gains. Wealth will be assessed based on its value at the time of acquisition or the time an order is made, whichever is greater. This approach prevents depreciation from eroding the effectiveness of the law and ensures that all unlawfully acquired wealth is subject to confiscation. And also to ensure fairness and proportionality, the bill incorporates essential safeguards, including the court's discretion to reduce the value of or refuse to make an unexplained wealth order if it would be manifestly unjust. This provision is vital to prevent the law from being applied in a manner that results in unreasonable or disproportionate outcomes. The court's discretion acts as a safeguard against potential abuses of power and ensures that the law targets only those who truly engage in serious criminal conduct. The bill also provides for restraining orders to prevent the disposal or dealing of property while unexplained wealth order proceedings are ongoing. This measure acts as a security mechanism to preserve assets that may be subject to forfeiture. By restraining the property of individuals under investigation, we ensure that they cannot dissipate their assets to avoid legal consequences. Restraining orders serve a dual purpose. They preserve the state's ability to recover unlawfully acquired wealth and prevent individuals from using their ill-gotten gains to fund further criminal activities. This measure is crucial for maintaining the integrity of the unexplained wealth scheme. Also, to protect the rights of individuals, the bill includes provisions that ensure statements made or evidence given by respondents cannot be used against them in other proceedings, except in cases of perjury. This safeguard protects the right to silence and the privilege against self-incrimination by ensuring that evidence provided in unexplained wealth proceedings is not used in other cases. We encourage transparency and honesty while protecting individual rights. The Confiscation Amendment Unexplained Wealth Bill significantly enhances the ability of Victoria Police and the DPP to target high-level organised crime figures who have previously managed to evade justice. These individuals often distance themselves from direct criminal activities using complex financial arrangements to obscure their involvement. By focusing on unexplained wealth, we can ensure that those who orchestrate and benefit from crime are held to account, regardless of their level of direct involvement. This bill builds on previous measures introduced in the Major Crime and Community Safety Legislation Amendment Act 2022, which expanded law enforcement powers to identify and seize digital assets. The new Unexplained Wealth Order is a natural progression of these efforts, further empowering law enforcement to combat organised crime effectively. Extensive consultation has been undertaken with key stakeholders to ensure that this bill is both effective and fair. Consultations have included Victoria Police, the Office of Public Prosecutions, the Department of Justice and Community Safety, and various legal bodies. While there has been broad support for the bill, some concerns were raised regarding safeguards and the potential impact on legal rights. These concerns have been carefully considered and addressed within the bill. Victoria Police and the Office of Public Prosecutions are broadly supportive of the bill, recognising its potential to disrupt organised crime. Some legal stakeholders, including the Criminal Bar Association and Victorian Legal Aid, have raised some concerns about the removal of certain safeguards initially proposed, such as the time limit on the calculation of wealth and the ability to access restrained assets for legal costs. These safeguards were removed to prevent the arbitrary restriction of the scheme and to ensure that unlawfully acquired wealth is effectively targeted. It is worth noting that the concept of unexplained wealth orders is not unique to Victoria. Similar legislation has been enacted in various jurisdictions worldwide, including the United Kingdom, Ireland and several Australian states. These laws have proven effective in disrupting organised crime and recovering unlawfully acquired assets. For instance, the UK introduced unexplained wealth orders in 2018 as part of its efforts to combat money laundering and illicit financial flows. The legislation has enabled UK authorities to target individuals who possess wealth disproportionate to their known legitimate income, leading to significant asset recoveries. Similarly, Western Australia has implemented unexplained wealth laws that allow for the confiscation of assets from individuals unable to explain the lawful origin of their wealth. These laws have been instrumental in tackling organised crime and reinforcing the message that crime does not pay. By aligning our approach with these successful models, we can enhance the effectiveness of our efforts to combat organised crime and safeguard our community. The evolution of asset confiscation laws highlights the ongoing commitment to combating organised crime and protecting the community. The introduction of the Confiscation Act 1997 marked a significant milestone in Victoria's legislative framework, providing authorities with the tools to seize assets derived from criminal activities. Over the years, the Act has undergone various amendments to address emerging challenges and close legal loopholes. The Major Crime and Community Safety Legislation Amendment Act 2022, for example, expanded the powers of law enforcement to target digital assets, reflecting the changing landscape of criminal enterprises. The Confiscation Amendment Unexplained Wealth Bill 2024 represents the latest step in this legislative evolution, reinforcing our commitment to staying ahead of organised crime and ensuring that our laws remain robust and effective. Acting President, the Confiscation Amendment Bill is a crucial tool in our fight against organised crime. By targeting the financial gains that drive these activities, we can disrupt and dismantle criminal networks, thereby enhancing the safety and security of our community. These reforms represent a comprehensive and balanced approach to asset confiscation, incorporating essential safeguards to protect individual rights while empowering law enforcement to effectively combat serious crime. The passage of this bill will ensure that those who profit from crime are held accountable and their ill-gotten gains are confiscated and put to good use for the benefit of the Victorian community as a whole. For these reasons, I commend the bill to the House.